Today we're here again with my friend Danielle Scavuzzo, and today we're going to talk about estate planning and what you can expect from that. So, what is an estate plan?
Well, an estate plan, often people say, well, I don't have an estate or whatever. Well, everybody has an estate. Mm-hmm. And so when we talk about estate planning, and which is mostly all we talk about at our firm, there's really three components to it. What happens to your things, your assets, when you pass away? Who gets them? How do they get them? What happens to take care if you become incapacitated? How do we take care of you? That's kind of the second component. If you have a stroke, develop dementia, that kind of thing. And then third, there's a tax component. Okay. And so there's really three components. Right now, our current, when we say taxes, what I'm referring to specifically are the estate taxes or death tax, we hear them called. Mm-hmm. Right now, those thresholds where you are susceptible to them are very, very high. So typically today, when I say we're going to talk about your estate plan, with 98% of our clients, what we're really talking about is protecting you if you're incapacitated, and then making sure your things go to whom you want them to go to and in the way you want them to get there.
So even if you don't have the 11 million or whatever millions of dollars in assets it is, it's still something that's important.
Absolutely. Everybody needs an estate plan, no matter how much or how little that you have. You may need different documents to get you from A to B, but everybody needs something.
So I hear people say, well, I've got a will. Isn't that enough?
Right. So a big misconception is that having a will means that if you pass away, your kids or your heirs won't have to take your assets through probate. And that's a really big misconception that I encounter all the time. A will is actually a probate tool. So when you have a will, it's got those big fancy letters, last will and testament at the top. Cross them out and write, Dear Judge. It's literally an instruction letter telling the probate judge, hey, here's who I want to get my stuff. My fancy legal term for your asset stuff. But here's who I want to get things. But the problem is, unless I'm sitting in front of the probate judge and I have an estate open, that will does nothing. So we want a will because if we end up in front of the probate judge, we want to be able to tell him or her where we want our things to go. But the goal of a good estate plan would be not to end up in front of the judge at all.
Okay. Then others say, well, I have pay on death or transfer on death on things. Is that sufficient or do we need more?
So it could be. And so when we say, okay, how do we avoid probate? And first off, I should throw in, why do we want to avoid probate? I think that's important to mention. Probate is that kind. There's two kinds of probate. This is probate at death. Mm-hmm. So when we pass away, if you have an asset that's in your name alone and it doesn't have a beneficiary on it, and it's not in a trust, it's just in your name, then when you die, if we take an imaginary eraser and kind of take your name off of that deed to a house, for example, or that bank account, when we look at it, we don't know who owns it. And so we have to go talk to the probate judge, and that is a method of establishing ownership over that asset. And so that's what's called probate at death. The other kind of probate is what's called living probate, and that's guardianships and conservatorships, and that deals with that other component of estate planning, which is incapacity. But on the probate at death, basically what happens is that, like I said, there's two ways we want to avoid that we can avoid it. The reason we want to avoid the probate, it's expensive. There's a statutory amount that the attorney can charge.
And doesn't that kind of
based
work
on
as
the
a
value.
floor instead of a ceiling?
Yes, it can. Often, though, the probate attorneys that we talk with actually bill hourly, and they end up even just because it's a very there's time deadlines they have to meet. So often they'll bill hourly, and it'll be as much as if they had just taken the statutory amount. But the statutory amount's huge, and same for the state of Kansas. They have the same. It's different, but the same concept is there. And so it's expensive, it's time consuming. In Missouri, if you have an open estate, it's a minimum 6 months. You have to publish notice to creditors. You have to notify any known creditors. And typically they're more like a year before a probate estate's closed. And so we generally say your estate, your family, whoever, is going to be out roughly 5 to 7% of the value of whatever the asset is, between attorney's fees, filing fees for the court. If it's an asset like real estate, we can't do anything with it until that estate is closed. So who's paying the insurance? Who's paying the taxes? So it really ties everything up. And so we don't want to go there. We don't want to be in probate. So how do we avoid it? There's two different kinds. transfer on death, pay on death, beneficiary designations. That's one way. And the other way is to do, and there's a lot of different kind of trust, but frequently we would, if I'm saying a trust, what we're talking about is what's called a revocable living trust. So there's two ways to avoid that probate.
Okay, and there are a lot of different trusts out there.
There are, and so one of the things that, if somebody says, well, I've got beneficiaries on my bank accounts, I have a beneficiary on my life insurance, on my vehicle, I have a transfer on death, TOD, TOD or POD, right? TOD, right. Pay on death on a bank account, POD. And that can work fine. And this is where sitting down with somebody is really important from my perspective, because it's not even, what we recommend is not necessarily only based, in fact, it's for sure not only based on what they have asset-wise. Mm-hmm. Just as important, if not more important, is taking a family dynamic picture and talking to people. How do people get along? What are the responsibility levels of everybody involved? And are there issues we need to know about? Because one of the things, to answer your question, on the transfer on death, mm-hmm. the beneficiaries, you're limited with what you can do. If you have a beneficiary on something, they get it outright. You can't control it at all, and which could be fine. The problem is, a lot of times, maybe we don't want to give a chunk of money to, say, somebody who's younger, or to someone with a disability, or someone maybe who just is bad with money, or has creditor issues, and we can't control that with the beneficiary designation.
So let's talk about a couple of those. Mm-hmm. First, someone who's younger. I have a 17-year-old son. Mm-hmm. What happens when he turns 18? Well,
and now what that kind of segues a little bit into so just to finish off the other thought, because that's very, very important. We want to do either beneficiaries or do a living trust, and that is how we avoid probate. And so what is the right choice for you really depends on all those different things we just talked about. Switching gears to that other component of estate planning, which is the protecting you from incapacity, that's really important. So your son, 17 years old, when he turns 18, or when any of us turned 18, our parents lost the ability to make any of our decisions, financial, medical, any of that, or to get any information from a doctor, for example. And so, well, shoot, what happens if, heaven forbid, that son is in a car accident after he turns 18? Or as an adult, something happens and we're incapacitated for any number of reasons. If we don't have certain documents in place, nobody can step in and talk for us or get information on our behalf, make our decisions. So shoot, if we can't, what's going to happen? And that's when we have to go talk to the probate judge again, and that's what's called an adult guardianship and conservatorship. Okay. And so you think of guardianships, you think of little kids, and that's true, that's in the same area of the courts, in probate court. But when you're an adult, if we don't have our wishes set out for us in the proper legal manner, we're stuck.
So, and I want to go back to something else here. You talked about the family dynamic and somebody with disabilities not getting some money. Why not, and what can we do about that?
So one of the advantages of a trust versus the beneficiaries is a trust, and not everybody needs a trust. It really depends on, you love it, but attorneys say it depends a lot, because it does. Yeah. So one of the advantages of a trust is we can control things. We can provide for out-of-order deaths, for example, things you don't want to think about. Maybe if you have two kids and one passes away, we want that share typically to go down to grandkids. If we just have beneficiaries on things, most of the time you can't do that. It just all goes to the survivor, and that's not what we want. So when we do a trust, we have the ability to control and put in all of these different contingencies. One of the things you can provide for is, what if I have a child who maybe has a creditor sitting out there, or has had a substance abuse problem or something like that, and it would be detrimental to them to get a chunk of money all at once. Or we have young kids in their 20s and they're good kids, but we don't want them to get all of our life insurance at once. We want to use it for their benefit, but we want to drag it out a little bit for them. A trust allows us to have different distribution options. And then one of those built in, and we see it a lot, is maybe we have somebody that has a child with a disability. They've got Down syndrome or some odd form of autism, and maybe they're going to be receiving Medicaid, or are already receiving Medicaid, or other benefits that are based on assets and on income. Well, if they receive a chunk of money, we have a problem. They're going to get kicked off of those benefits, and all the money is going to be depleted, and then they're going to have to go through all the rigmarole of reapplying, and the money's gone. And so through a trust, we can do what's called a supplemental needs trust, and we can plan getting to pick people who would be in charge of that money for your loved one, and put them in place so that they could remain on their benefits, but have this pool of money here to supplement what the benefits are not covering.
Okay. I hear a lot of people talking about, I have a power of attorney. What does the power of attorney do for me? And who needs one?
So power of attorney, that's part of that when I mentioned before, after we turn 18, nobody can make our decisions for us. There's two kinds of powers of attorney. There's one that deals with all things medical in terms of hospitals, doctors, and information, making medical decisions for us. And then the other kind is a general or a financial power of attorney. And that basically deals with everything else. So when we turn 18 and our parents stop having the ability to make those decisions, powers of attorney, either by themselves and or if you're older, perhaps coupled with a trust, are how we deal with putting people in place to be able to step in for us if we're incapacitated. Or maybe, you're just 90 and tired and you want to have somebody else make the phone call to your health insurance for you,
Yeah.
And the powers of attorney allow us to designate someone or multiple people to be able to step in and do that for us.
So does location make a difference? For instance, my wife works in Kansas. So what happens
Right.
if she gets in an accident in Kansas?
So on the medical side, yes, it actually does. So medical powers of attorney are a little bit different. If you do a trust in Missouri and then you move to Oklahoma, as long as it was validly executed in Missouri, even a will and something happened and we had to file a will in Oklahoma for you, they'll recognize the Missouri will. Okay. We may have to cite a few different things, but they would recognize it. Medical powers of attorney are a little unique. The state where you're in the hospital is what state law applies. And so even if you're a Missouri resident, if you're taken to KU, we need to comply with Kansas law on the medical power of attorney. So being this close to the state line, it's really important you have a document that at the least complies with these two states. And at the best, hopefully, which ours, we try to hit a lot of states' quirks, and that way it travels with you. And worst case, it won't be declared invalid. And even if we haven't hit a specific state's quirk, we would have the ability to move the person back to Missouri or Kansas where we know it works.
Great information. Thanks for being here today.
Thank you for having me.
And this has been Bet on You. Hopefully you found something that you can use in this, and we'll see you next time.